The Indian Constitution, a document birthed from the crucible of a long freedom struggle and the aspirations of a newly independent nation, meticulously delineates the powers between the union government and the state governments. This division was not an afterthought. It was a conscious design to accommodate the immense diversity of India. The framers of our constitution understood that a country of such continental proportions, with its myriad languages, cultures, and regional specificities, could not be governed effectively from a single central point. Therefore, they wove a federal structure, albeit one with a discernible tilt towards a strong centre, a necessity perceived in the aftermath of a painful partition and the need to forge national unity. This framework is crucial for understanding how India functions. The seventh schedule of the Constitution is the cornerstone of this division of powers. It lays out 3 legislative lists. These are the Union List, the State List, and the Concurrent List. The Union List enumerates subjects over which the Parliament has exclusive power to legislate. These are matters of national importance, such as defence, foreign affairs, and currency. The State List, conversely, details subjects over which the state legislatures generally hold exclusive sway. The Concurrent List contains subjects where both Parliament and state legislatures can make laws. This intricate distribution aims to create a harmonious balance, allowing for regional autonomy while preserving national integrity and strength, a complex dance of authority. This essay will delve into the specifics of the State List and the Concurrent List. We will explore the exclusive powers vested in the state governments. We will also examine the circumstances under which the Union Parliament can intervene in the state's legislative domain. Furthermore, the essay will shed light on the distribution of executive powers. It will also discuss the Union's power to issue directions to the states, particularly during normal times, national emergencies, and financial emergencies. Understanding these nuances is vital. It reveals the operational dynamics of Indian federalism. It shows how power is shared and at times contested within this vast democratic experiment. The very notion of a federal structure implies a partnership. It suggests a cooperative relationship between the central authority and the constituent units. However, the Indian model, often described as quasi-federal or federal with a strong unitary bias, reflects historical anxieties and pragmatic considerations. The ghost of colonial centralization perhaps still lingered in the minds of those who drafted the governing principles. They sought to build a nation that was resilient, capable of withstanding vociferous tendencies, while also empowering its diverse regions to manage their own affairs. The balance, therefore, is delicate. The State List, or List 2 in the 7th schedule, carves out a significant sphere of influence for the state governments. This list originally contained 66 items, though this number has since been revised to 61. These are subjects where state legislatures have the exclusive power to make laws under normal circumstances. The rationale behind this exclusivity is straightforward. These are matters that are considered to be of local or regional importance. They require understanding and management tailored to the specific context of each state. This arrangement allows for governance that is closer to the people. It enables responses that are attuned to local needs and aspirations, fostering a sense of participation and ownership in the democratic process within each state. Among the prominent items in the State List are public order and police. These are fundamental to the maintenance of peace and security within a state's territory. The responsibility for day-to-day law enforcement, therefore, rests squarely with the state government. This is a critical power. It directly impacts the lives and safety of citizens. Another vital area is public health and sanitation, hospitals and dispensaries. This empowers states to address the health needs of their populations, manage healthcare infrastructure, and implement public health initiatives. Given India's diverse health challenges, which vary significantly from one region to another, state-level control over this sector is deemed essential for effective and responsive healthcare delivery. Agriculture, including agricultural education and research, protection against pests, and prevention of plant diseases, is also a state subject. This is profoundly important in a country where a large percentage of the population depends on agriculture for their livelihood. Different states have varying agroclimatic conditions, cropping patterns, and farmer communities. State-level legislation allows for policies that are tailored to these specific agricultural landscapes. Similarly, water, that is, water supplies, irrigation and canals, drainage and embankments, water storage and water power, subject to the provisions of Entry 56 of List 1, Union List, falls under state jurisdiction. This acknowledges the localized nature of water resource management, a critical issue across the Indian subcontinent. Other significant items include land, which covers rights in or over land, land tenures, and agricultural land. It also includes local government, that is, municipal corporations, improvement trusts, district boards, and other local authorities for self-government. This empowers states to structure and manage governance at the grassroots level. Fisheries, industries, subject to certain union provisions, state pensions, burials and burial grounds, and betting and gambling are also part of this list. The state list, therefore, provides a substantial legislative and executive domain for the states. It allows them to shape policies that directly affect the daily lives and well-being of their inhabitants, reflecting the federal spirit of the Constitution. The exclusive jurisdiction of state legislatures over items in the state list is a fundamental tenet of India's federal structure. Article 246, 3 of the Constitution explicitly states that, subject to certain clauses, the legislature of any state has exclusive power to make laws for such state or any part thereof with respect to any of the matters enumerated in List 2. This provision is intended to ensure a degree of autonomy for the states. It empowers them to govern effectively within their defined spheres, without undue interference from the central government in these specific areas. This autonomy is crucial for addressing local issues with local understanding, fostering a responsive and accountable government at the state level. This legislative sovereignty means that laws made by a state legislature on a state list subject will prevail within the geographical boundaries of that state. For instance, a law concerning local policing methods in Kerala will be determined by the Kerala state legislature. Similarly, agricultural policies suited to the arid regions of Rajasthan will be framed by its own legislative body. This allows for a diversity of approaches across the country. It acknowledges that a one-size-fits-all policy dictated from the centre may not be effective or appropriate for every state. The wisdom of this distributed authority lies in its capacity to accommodate India's vast regional variations and specific needs. However, this exclusivity is not absolute and is subject to other provisions of the Constitution, which we shall explore later. But in normal circumstances, the domain of the state list is sacrosanct. The Union Parliament is not expected to legislate on these matters. This clear demarcation is intended to prevent legislative overreach by either the centre or the states into each other's designated territories. It aims to minimize friction and promote a harmonious working relationship between the two levels of government. The strength of this framework lies in its clarity, providing a predictable environment for governance and policy making within the states, allowing them to plan and execute long-term strategies for their development. The significance of this exclusive power cannot be understated. It underpins the federal character of the Indian Union. It gives substance to the idea that states are not mere administrative units of the centre but possess their own distinct constitutional identity and powers. Subjects like public health, agriculture, and local government are intrinsically tied to the well-being and development of local communities. Entrusting these to the states ensures that governance is more accessible, accountable, and responsive to the people it directly affects. This principle of subsidiarity, where decisions are taken at the lowest appropriate level, is vital for a vibrant democracy, and the state list is a key enabler of this principle in the Indian context. While the state list defines an exclusive legislative domain for the states, The Indian Constitution, in its characteristic pragmatism, provides for certain exceptional circumstances where the Union Parliament can legislate on subjects enumerated in this list. These provisions reflect the Constitution's underlying concern for national unity and integrity, and its recognition that some situations may require a coordinated national response. One such circumstance arises under Article 249. If the Rajya Sabha, Council of States, declares by a resolution, supported by not less than 2/3 of the members present and voting, that it is necessary or expedient in the national interest that Parliament should make laws with respect to a matter in the state list, Parliament can then legislate on that subject for the whole or any part of India. Another scenario is during the proclamation of a national emergency under Article 352. When a national emergency is in operation, the legislative competence of Parliament expands significantly. It can make laws on any matter in the state list. While the state legislature's power to make laws on state subjects is not suspended, the union law will prevail in case of any inconsistency with a state law. This provision is designed to ensure that the union government has the necessary powers to deal effectively with grave threats to the nation's security or stability. The centralization of power during such critical times is seen as a necessary measure for cohesive and decisive action across the country. Parliament can also legislate on state subjects if 2 or more states pass resolutions requesting it to do so. According to Article 252, if the legislatures of 2 or more states find it desirable that any of the matters within their exclusive legislative competence should be regulated by Parliament, and they pass resolutions to that effect, Parliament can then pass an act for regulating that matter. Such an act can then be adopted by any other state by passing a similar resolution. This mechanism allows for uniformity in law across consenting states when they themselves perceive a need for it, without a direct imposition from the centre. It is a form of cooperative federalism initiated by the states themselves. Furthermore, Parliament has the power to make laws for implementing any treaty, agreement or convention with any other country or countries, or any decision made at any international conference, association or other body. If such implementation requires legislation on a matter in the state list, Parliament is empowered to do so. This ensures that India can fulfill its international obligations effectively, even if it means encroaching upon the normal legislative domain of the states. These exceptions, while significant, are generally intended for specific situations and underscore the Constitution's flexible approach to federalism, balancing state autonomy with national interests and obligations. Section 5. The Concurrent List, a realm of shared legislative responsibility. Beyond the exclusive domains of the Union and the states lies the Concurrent List, or List 3 of the 7th Schedule. This list currently contains 52 items, originally 47, with some transfers from the state list via amendments, notably the 42nd Amendment. These are subjects on which both the Union Parliament and the state legislatures can make laws. The very existence of a concurrent list signifies a need for uniformity in certain areas of law across the country, while also allowing for state-specific variations where necessary. It represents a middle path, a domain of shared responsibility, embodying the cooperative spirit that should ideally define centre-state relations. Prominent subjects in the concurrent list include criminal law and criminal procedure. This allows for a largely uniform criminal justice system throughout India, which is essential for legal consistency and the effective administration of justice. Marriage and divorce, infants and minors, adoption, wills, intestacy, and succession are also on this list, enabling national standards for personal laws while allowing for some regional adaptations. Another critical area is education, including technical education, medical education, and universities. This was moved from the state list to the concurrent list, reflecting a growing consensus on the need for national policies and standards in this vital sector for human development. Forests, protection of wild animals and birds, and economic and social planning are other key entries. These subjects often transcend state boundaries and require coordinated efforts. For example, environmental protection and economic development strategies frequently necessitate a national perspective alongside regional implementation. The inclusion of trade unions, industrial and labor disputes allows for a framework of labor laws that can be both nationally guided and locally adapted. Price control, factories, electricity, and newspapers, books and printing presses also feature, indicating areas where both levels of government have a legitimate interest in legislation and regulation. In the event of a conflict between a union law and a state law on a concurrent list subject, the law made by Parliament generally prevails. This is enshrined in Article 254 of the Constitution. However, there is an exception. If a state law on a concurrent subject has received the assent of the President, it will prevail in that state even if it is repugnant to an earlier union law on the same subject. Parliament can nevertheless subsequently enact a law on the same matter, including a law adding to, amending, varying or repealing the state law. This intricate provision highlights the nuanced balance of power, generally favouring the Union in case of conflict, yet offering a window for state legislation to hold its ground under specific conditions. Section 6. Executing authority implementing laws on state and concurrent lists. The distribution of legislative powers is naturally accompanied by a corresponding distribution of executive powers. The general principle is that the executive power of a state extends to all matters with respect to which its legislature has the power to make laws. This means that for subjects in the state list, the executive authority rests exclusively with the state government. The state executive, comprising the governor, the chief minister, and the Council of Ministers, is responsible for implementing laws passed by the state legislature on these subjects. This includes maintaining public order, managing agriculture, overseeing local governments, and administering public health services within the state's territory. This executive autonomy is crucial for the effective functioning of state governments. It allows them to translate legislative intent into tangible action, tailored to their specific administrative capacities and local conditions. For instance, a state law aimed at improving primary education would be implemented by the state's education department, deploying resources and personnel as it deems fit. Similarly, the state police force, under the control of the state government, is responsible for enforcing laws related to public order and crime prevention. This direct line of executive responsibility is vital for accountability and for ensuring that governance is responsive to the needs of the state's population. Regarding the concurrent list, the executive power ordinarily rests with the states. Even though both Parliament and state legislatures can make laws on these subjects, the implementation of these laws, whether made by Parliament or the state legislature, is generally carried out by the state governments. This is a significant aspect of Indian federalism. It means that even when Parliament legislates on a concurrent subject, such as education or forests, the primary responsibility for putting that law into effect on the ground usually falls upon the state machinery. This arrangement acknowledges the administrative reach and local presence of state governments. However, the Constitution also provides that Parliament can, by law, confer executive powers upon the Union government or its authorities for the administration of laws made by Parliament on concurrent list subjects. This is not the default position, but an option available to Parliament if it deems it necessary for the effective implementation of a particular Union law. This provision ensures that the Union is not entirely dependent on state machinery for the execution of its laws in the concurrent sphere, especially in matters of national importance or where uniformity of implementation is critical. Thus, while states primarily execute laws on concurrent subjects, the Union retains the ability to step in when required, showcasing another layer of flexibility in the federal structure. Section 7. The Union's Advisory Role, Guidance to States in Ordinary Times. The Indian Constitution, while delineating separate spheres of authority, also envisages a cooperative framework where the Union government can guide and advise state governments even in normal times. This is not necessarily about coercion, but about ensuring coherence and adherence to the national interest and constitutional principles across the diverse states. Article 256 of the Constitution lays down a fundamental obligation. The executive power of every state shall be so exercised as to ensure compliance with the laws made by Parliament and any existing laws which apply in that state. Furthermore, the executive power of the Union extends to the giving of such directions to a state as may appear to the Government of India to be necessary for that purpose. This provision underscores a hierarchical element within the federal structure. It mandates that state governments must act in a way that upholds and facilitates the implementation of union laws. If a state were to, for instance, obstruct the functioning of a central agency or the implementation of a parliamentary statute, the union would be constitutionally empowered to issue directions to ensure compliance. This power of direction is a tool to maintain the supremacy of union laws within their legitimate sphere, and to ensure that the governance of the country proceeds smoothly and uniformly where national legislation applies. It acts as a safeguard against any state action that might undermine the legal framework established by Parliament. Beyond this general obligation, Article 257, Clause 1, further elaborates that the executive power of every state shall be so exercised as not to impede or prejudice the exercise of the executive power of the Union. The Union's executive power also extends to giving directions to a state as may appear necessary for this purpose. This means states must not only comply with Union laws, but also ensure their administrative actions do not hinder the Union's own executive functions. For example, a state cannot take actions that would obstruct the functioning of railways or national highways, which are vital for national connectivity and fall under Union jurisdiction or interest. The Union can also issue directions to states regarding the construction and maintenance of means of communication declared to be of national or military importance, as per Article 257, Clause 2. Similarly, the Union can direct states on measures to be taken for the protection of railways within the state, as stated in Article 257, Clause 3. While the Union bears the additional costs incurred by the state in fulfilling these specific directions, the power itself highlights the centre's role in ensuring critical national infrastructure is maintained and protected. These directive powers, operative even in non-emergency situations, illustrate the Constitution's intent to create a strong, cohesive nation where states function in concert with overarching national objectives, guided, where necessary, by the Union. Section 8. National exigencies, Union supremacy during emergencies. The balance of power between the Union and the states undergoes a significant transformation during periods of emergency. The Constitution provides for 3 types of emergencies: national emergency, state emergency or President's rule, and financial emergency. During a national emergency proclaimed due to war, external aggression or armed rebellion, the federal structure can effectively become unitary. Parliament gains the power to legislate on any matter in the state list. The Union government can give executive directions to any state on any matter, meaning the state governments, while not necessarily dismissed, come under the comprehensive control of the centre. This drastic shift is deemed necessary to manage grave threats to the nation cohesively. Under Article 356, if the President, on receipt of a report from the Governor of a state or otherwise, is satisfied that a situation has arisen in which the government of the state cannot be carried on in accordance with the provisions of the Constitution, President's rule can be imposed. In such a scenario, the President may assume to himself all or any of the functions of the government of the state and all or any of the powers vested in or exercisable by the Governor or any body or authority in the state other than the legislature of the state. The powers of the state legislature are declared to be exercisable by or under the authority of Parliament. This provision, though intended as a last resort, has often been a subject of political controversy regarding its alleged misuse. During a financial emergency, proclaimed under Article 360, If the President is satisfied that a situation has arisen whereby the financial stability or credit of India or any part of its territory is threatened, the Union's authority over financial matters extends significantly. The Union can issue directions to any state to observe such canons of financial propriety as may be specified in the directions. Such directions may include a provision requiring the reduction of salaries and allowances of all or any class of persons serving in connection with the affairs of a state. Money bills or other financial bills passed by the state legislature may be required to be reserved for the consideration of the President. This allows the centre to enforce fiscal discipline across the states. These emergency provisions, particularly those related to national and financial emergencies, demonstrate a clear constitutional pathway for the Union to assume overriding powers. The rationale is the preservation of national security, unity, and financial stability. While these powers are extraordinary and intended for exceptional circumstances, their existence underscores the ultimate supremacy of the Union in times of crisis. The capacity of the federal system to transform into a more unitary one during such periods is a distinctive feature of the Indian Constitution, reflecting the framers' concern for maintaining the integrity of the nation above all else, even if it means temporarily curtailing state autonomy quite substantially. Section 9. Conclusion. Maintaining India's intricate federal balance. The division of powers between the Union and the states in India, as meticulously laid out in the Constitution, particularly through the 7th Schedule, is a testament to the complex and pragmatic vision of its framers. They sought to build a system that could accommodate India's staggering diversity while ensuring national unity and administrative efficacy. The state list grants significant legislative and executive autonomy to the states, empowering them to address local needs concerning crucial areas such as public order, agriculture, and public health. This fosters a sense of regional self-governance and allows for policies tailored to specific local conditions, which is essential in a country as varied as India. The Concurrent List provides a platform for shared responsibility, allowing both the Union and the states to legislate on matters of common interest, such as education, forests, and criminal law. This mechanism promotes uniformity where necessary, while still permitting states to adapt laws to their unique circumstances. The provisions allowing Parliament to legislate on state subjects under exceptional conditions, such as a resolution by the Rajya Sabha in the national interest or during a national emergency, reflect a built-in flexibility. This adaptability ensures that the nation can respond cohesively to overarching challenges or crises, underscoring the Constitution's pragmatic approach to federalism, where the national interest can at times supersede regional autonomy. The distribution of executive powers largely mirrors the legislative division, with states primarily responsible for implementing laws within their domain and also typically those on the concurrent list. However, the Union's power to issue directions to states, both in normal times to ensure compliance with Union laws and protection of national interests, and more extensively during emergencies, highlights the Constitution's inherent inclination towards a strong centre. This framework, often described as quasi-federal, was deliberately designed to hold the nation together, a paramount concern in the aftermath of independence and partition. The careful calibration of authority seeks to prevent centrifugal forces from undermining the Union. Ultimately, the relationship between the state and the Union in India is one of dynamic federalism. It is not static, but continually evolving through political practice, judicial interpretation, and constitutional amendments. The balance of power is delicate, requiring constant negotiation, cooperation, and respect for the constitutional boundaries by both levels of government. While the tilt towards the Union is undeniable, the powers vested in the states are substantial and vital for democratic governance. The successful functioning of this intricate federal balance is crucial for India's continued progress, ensuring that both national unity and regional aspirations are effectively harmonized for the greater good of all its citizens.